Dear Professor Susskin, dear colleague Kellerhals als co-organizer, dear colleagues, dear guests. People with great foresight, like our speaker today, Richard Susskin, have known it for a long time. Other people have known it at least since ChatGPT was widely used. Our profession is changing. Much of it will be barely recognizable in a few years' time. Today, Professor Susskin will be speaking about the future of legal services based on his highly regarded books, and therefore about the future of the profession, training, further education and research in our field. Of course, not everything will change fundamentally from one day to the next, but it will be the day after tomorrow, at the latest, before lawyers are required to have a different skill set than we do have today. For us universities, this means that we must think in different directions. Firstly, we as a faculty are asking ourselves what we need to teach today's 20-year-olds to prepare them for the future of the profession. It has long been clear that it is not longer enough just to teach them the basics of the legal system. But what additional skills do we need to teach so that people are ultimately equipped for the professional life? Secondly, our science itself is changing. Legal science has, up until now, a lot to do with system knowledge and knowledge of standards and case law. However, this knowledge is of much less value today because it is much easier to access electronically. It's easier accessible electronically. So what does our science consist of when knowledge becomes secondary to other things? In both cases, the answers we will give will be probably similar. We need to provide enough knowledge so that legal thinking has material to connect to, but no more detailed knowledge that is relatively easy to access electronically. In other words, more orientation and method than details. Finally, the question that is not less central for us is what all lawyers who have already completed their studies and are in the professional world should do at the moment. This is where the area for which Professor Kellerhals and I are jointly responsible in our faculty comes in, namely continuing legal education. We need to create and expand programs so that people in practice can keep up with the latest developments in teaching and research alongside their work. I am proud to be able to report here that the expansion of the continuing education programs, which we have strategically prescribed for ourselves, is progressing rapidly. At the next faculty meeting alone, we will approve 3 new CAS programs and 1 master's program, which means that our faculty will be offering around 25 different continuing education programs by 2025. I admit that only a small number of these programs are directly related to the rapid developments in the field of law, but some programs are specifically geared towards this. However, before we reorganize our teaching, our research and our continuing education, we wanted, as I said, to be brought up to date by one of the leading experts in the field. And now it comes to you. Your expertise is required here. Thank you for being here. Thank you for sharing, as you said, your questions, at least your questions with us, but we are also hoping for some answers. Please, the floor is yours.
Well, thank you very much for that kind introduction. It really is a great honor to be speaking at your university. I'm going to speak to you for 45 minutes, and then we're going to have an opportunity for some kind of conversation. So here's where I'd like to take you. I'd like to suggest to you, first of all, the mindset you should have in addressing the questions you have mentioned. And secondly, I want to talk about the drivers of change. What factors are bringing about what I believe we'll see more change in the next decade in law than we've seen in the past century. One of these drivers of change is technology, and I'll spend some time giving you a sense of what I think is happening in the world of technology. That will lead me quite naturally to the field of artificial intelligence. Now, I wrote my PhD in artificial intelligence at Oxford University from 1983 to 1986, So I spent much of my life, most of my working life, thinking about the impact of AI on lawyers and the courts. And I want to share some of that with you. Whenever there's a conversation about AI, there's very quickly a conversation about jobs. What jobs will there be in the future? And I want to identify the range of skills I think new legal professionals will need. And I think that will begin to move towards the kinds of answers that you're wanting. If we can get a sense of what it is that legal professionals will do in the future, we can get a strong sense of how best we might prepare them for that future. For those of you who are involved more in practice, in one way or another, I'd want briefly just to mention what I've said, how it applies to what we call strategy, how it is you organize and plan for the future, but that equally applies to law schools. And finally, and I'll explain it when I get there, I want to talk about neurosurgery. So let me start off with mindset and start off with a slide I always use when I present. You'll see this before you, a slide of a gleaming power drill. And the story that goes along with this is about Black & Decker, who are one of the world's leading manufacturers of power tools. And apparently Black & Decker, when they recruit new executives, they take them off on a course, sit them down in a room, not as wonderful as this, but they sit them down in a room and they put up a slide very much like the slide before you and say to the new executives, this is what we sell, isn't it? And they all agree. They say, of course that's what we sell. We're Black & Decker. Well, the trainers say with some satisfaction, that's not actually what we sell because that's not really what our customers want. This, they say, is what our customers want. And it's your job to find ever more creative, imaginative, competitive ways of giving our customers what they want. And I think there's a very strong lesson here for lawyers and law students and law professors. Because I'm afraid we're in the legal world, we tend to be of power drill mentality. We tend to look at the drill today and think, how do we make it cheaper, quicker, better? Not often enough do we take the step back and ask as lawyers, what's the fundamental value we bring to those we serve? What's the fundamental value of lawyers in society and community? And here's the vital bit. In a digital society, might we deliver that value in entirely new ways? The current way of delivering legal service, the power drill, is one-to-one consultative advisory service. That's embodied and reflected in lawyers' work around the world. But what I'm saying to you is the outcomes of that process might be delivered in entirely new ways in an AI-based society. And that's the story I want to discuss with you today. I want also for you to bear in mind, under the heading of mindset, a distinction between automation and innovation. And I use these words in very specific senses. By automation, I mean the computerization, the streamlining, the optimizing of how we work today. The first 65 years of legal technology has been devoted to automation. We have grafted, we have placed technology onto our existing ways of working. So the point of technology has been to sustain, enhance, and improve traditional practice. And of course, we have had all sorts of efficiency gains and productivity gains. But as I've looked across the world in other industries, in other sectors, and looked at genuinely game-changing applications of technology, they're very rarely examples of automation. Far more often, they're examples of innovation. And by innovation, I mean the use of technology to allow us to do things that previously were not possible. That's the great excitement about technology, to harness the power of existing and emerging technologies, not simply to computerize how we've always worked, but to allow us to provide a deeper, better service and more, but to work in entirely new ways. For too long, people have been of an automation mindset in law. Somehow what's really important, they think, is how lawyers have always worked. But we should widen our horizons. Technology will go far beyond simply supporting human beings. It will allow us to work in entirely new ways. It will allow us to solve problems that in the past could not even be solved by human beings. But why do we need to think about this anyway? Well, I argue there are three drivers of change in the legal marketplace. I call them the more for less challenge, new providers, and technology. I want to say a little about more for less and new providers, and then a lot about technology. Whenever I do research with major organizations, and I speak to their in-house counsel, their general counsel, they usually say three things to me. They say we're under pressure to spend less on law firms. They say we're under pressure to reduce the size of our legal teams. And yet they also say we have more legal and compliance work to do than ever before. And in my research that goes back to 2004 that I did for a major London law firm, I saw the first signs of this more for less challenge. The reality is, and no one I don't think can sensibly argue against this, it's not that the need for legal services nowadays is somehow lessening. In fact, we live in a more complex world, a more industrialized world, a more regulated world. The need for legal help is increasing. The interesting question is, how is that need best going to be satisfied? The traditional way of it being satisfied was law firms and in major organizations, in-house legal departments. But there might be entirely different ways of sorting out legal problems. And remember, this is not simply a difficulty or a challenge for major organizations. For individual citizens around the world, in many jurisdictions, they cannot afford legal services. This is the access to justice problem. Often, immersing yourself in the legal system, I'm afraid, becomes combative, it becomes time-consuming, it becomes anxiety-inducing, and it becomes very costly. So we have to think of ways that we can deliver more legal service. We can make legal guidance, assistance, the resolution of disputes more widely available and yet at less cost. And there's only two ways of doing that. One is by using lower cost labor. And you may have heard, for example, in the United States, very common, and in the UK too, outsourcing of legal services, offshoring of legal services. The use of paralegals with playbooks and so forth. But the idea here is that some legal work can be handed over to people who are not qualified as lawyers because you can reduce some of the work to process. The other option to meet the more for less challenge is technology itself. Now, historically, technology was used in the back office of law firms for word processing, for accounting, for electronic mail. But now we're seeing the emergence of systems that are actually taking on tasks that historically we thought could only be undertaken by human beings. So here we begin to see a new narrative emerging, that the way to meet the more for less challenge is through technology. But there's a second driver of change that I find interesting in the legal market, and it applies differently in different jurisdictions. And I'll give you two examples. But the point is that we are seeing new players in the legal marketplace, new competitors, which are introducing, I think, a healthy competitive friction. In some jurisdictions like England and Wales, it's possible for non-lawyers to own legal businesses. It's possible to have external capital, venture capital, private equity in legal businesses. It's possible to set up what we call alternative business structures. Now, that's not true in all jurisdictions, but we have seen in response to this and other developments, for example, the big four accounting firms now beginning to deliver legal services. Maybe not the most complex work, but a lot of the work that goes on, even in the largest deals and disputes, arguably is actually not legal work at all. A lot of the document review certainly can be done by systems, and we'll discuss that later. But these big accounting consulting firms are wildly larger than even the largest law firms in the world. One of my clients, for example, is Deloitte, and it has more than 500,000 people. And it's got a turnover of something like $65 billion. And so when they take the legal market seriously, I think they're going to have impact. Maybe not over the next couple of years, but we can see it over the next decade. Interestingly, for me at least, at the other end of the spectrum, a more important driver of change, I think, for the market is the legal technology startup industry. And I know in Switzerland there's quite a few legal technology startups too. If I'd been standing here 15 years ago, there were about 200 legal tech startups in the world. There are now, according to my research, about 4,000. And about 12 or 1,300 of these are trying to do to law what Amazon did to book selling. They're trying fundamentally to disrupt the law. Now, I don't think we will see a single Uber or eBay or Amazon in the law, but I do think we will see it in individual practices or activities within the law. So I don't think there's any general purpose business solution to the challenge of law. It's far too varied a field. But I think from these 1,200, most of whom sadly will die, we will probably most likely see some exciting, innovative, very disruptive developments in the legal world. So that's the second driver of change. The first is the more for less challenge. The second is new providers in the legal marketplace, which we have to see strategically and in policy terms alongside the gradual liberalization and deregulation, at least in some jurisdictions. And thirdly, and most importantly, and hinted, of course, already, is technology. Now, I'm half a lawyer and half a technologist, and as technologists, we all have different ways of explaining what's going on in the world of technology. I do it under 5 headings. And the first thing I want you to, and this is the big takeaway, if you only have one takeaway from today about what's happening in technology, it is this, that our systems are becoming increasingly capable. Hardly a day passes that we don't hear news of some new system or technology or startup or breakthrough. And vitally, we're hearing news of systems that, as I say, are taking on tasks that we thought in the past could only be undertaken by human beings. Our systems are becoming increasingly capable, and they're doing so at a very rapid pace. So forget about blockchain or machine learning, all these enabling technologies for a second. The big point is our systems are doing more and more. And that is a remarkable phenomenon. A good example of this, some research that was done by Dan Katz in the United States. And this was looking, and I'm going to talk a little later about this, at GPT, the new AI system. Well, not so new, the end of 2022 it came out. But there were earlier versions of GPT. And what you see mapped here is the use of GPT. It was tested against the multi-state bar exam in the United States. And you could see that the version, ChatGPT, the one in red, the most rightwards one in red, you can see that that was below the average pass rate. In fact, ChatGPT, that's the first version, passed 2 out of the 7 multi-choice papers. GPT-4 passed all 7 papers, multi-choice, and actually passed the written paper as well. And what I'm urging on you is this idea, in even half a version, we saw this massive leap. Our systems are becoming increasingly capable. Note now that GPT-4 in green is now outperforming the average student pass rate. And we're still warming up. It's still the beginning. How is this happening technologically? Well, the underpinning technologies are growing at an explosive, literally exponential rate. You know that curve that goes like that. We're past the knee of the curve now. Whether it be processing power or hard disk capacity or memory or bandwidth, we're seeing the most phenomenal advances in the underpinning technologies. So take, for example, neural net technology. Don't worry too much about what that is, but just note it as the main technology that underpins AI systems of today. Neural net's performance is doubling every 14 weeks just now. Think of that mathematical progression. It means within a 5 to 6 year period, neural net performance increases 300,000-fold. Now, we should be amazed, I think we should be, at the developments, the recent developments in AI, GPT and all the rest of it. But I think more amazing is that in a period before the end of this decade, the underpinning technologies will be improving in performance more than 300,000 times. So we live at this time of remarkable growth, a time of greater technological advance than humanity has ever witnessed. It's happening in our lifetimes, and we have to think deeply what it means for the fields in which we work, and in our case, in law. There's also, and this is remarkable, I think, no finishing line. No one in Silicon Valley or South Korea or China is dusting their hands off and saying, job done, that's technology, let's move on to something else. Quite the reverse, the pace of change is accelerating. And I find this wholly remarkable. And even 2 days ago, we saw the emergence of another GPT system. And I've seen a couple of demos online. For example, via 2 iPhones, 2 AI systems communicating with one another. It is very spooky indeed. And I say to you again, these systems are becoming increasingly capable. We're just warming up. This is very early in the days of advanced AI. And what I find particularly amazing is what I call the as yet uninvented systems. That we're only about 70 years into AI, just now 75 years in. In all likelihood, the greatest advances still lie ahead. I believe our lives will be transformed by 2030 by technologies and techniques that have not yet been invented. You might think that sounds science fictional, but I've been plotting the developments of AI over the last 75 years. The big breakthroughs used to come every decade. They're now coming about every 18 months or even quicker than that. And if you think it's daft to say our lives will be transformed by 2030, look at October 2022 when ChatGPT hadn't been invented. The world has in part been turned on its head by that technology, and it's still at a very early stage of development. Or think of social media. In the year 2000, when I was involved in setting up at Oxford University, the Oxford Internet Institute, Facebook hadn't been invented, Twitter hadn't been invented, eBay might have been invented, but certainly the main systems that we use today, of course, TikTok hadn't been invented, of course, Instagram hadn't been invented. All the systems that dominate the way that many of us communicate and collaborate were not even in our contemplation. So it doesn't take many years of technological breakthrough to bring great advances. And I have no idea what these obviously, I have no idea what these advances will be. They may indeed come in law from people in this room, who knows? But what I do know, and this scares me the most, is these systems are already so advanced that we don't actually understand how they work. I'm not saying we don't understand how they've been designed, but what I'm saying is in operation, we don't quite understand why they do or how they do what they do. I was struck when I read this book by Stephen Wolfram, who's one of our generation's great computer scientists, and he very quickly wrote a book called What is ChatGPT Doing and Why Does It Work? And I was struck so often by how he says, and we don't know why it does this, or this is surprising, or this is amazing, or we have no theory to explain this. This is one of the leading computer scientists in the world. Now, I say again, it's not that we don't understand that we've gathered huge amounts of data and we use algorithms. We know that. But we do not know for any particular interaction how it is the system arrived at whatever it generates in our direction. And so this idea that people have about these systems being more explainable, I think actually may simply be a pipe dream. They're already too complex for us to understand. So that's my summary of where we're at in technology. Some of it's quite exciting, some of it's quite upsetting, in fact. But our systems are becoming increasingly capable at a rapid rate. We're seeing an exponential, explosive growth in the underpinning technologies. There is no apparent finishing line. I believe the most advanced systems have yet to come and will come quite quickly. And already we don't quite understand how these systems work. It's a remarkable snapshot, I think. And I present it to you not as a piece of science fiction, but again, I say, we live at this remarkable period of technological advance. So let's turn to AI. And I said before that I did my research in the 80s in AI. I also co-developed the world's first AI system for lawyers, fully operational AI system for lawyers. And I say both of these things not just to assure you you're in safe hands this evening, but actually to give some heft to what I'm about to say, because there's a huge amount of discussion in the legal market and beyond about the impact of AI in law. And I want to suggest to you this, that I think most of the short-term claims that are being made about the impact of AI in law are hugely overstating its impact. But on the other hand, and far more importantly, I think most of the long-term predictions are hugely understating its impact. Do I think, as some commentators who are quite new to the field bluntly, say things like AI will transform the legal profession of the courts within 2 or 3 years? Do I think that? I absolutely don't think that. What about by 2030 and beyond? Yes, I think we will see some pervasive, irreversible revolutions within the legal market, which begins to give us a sense, begins to offer an answer to one of your many questions about the timescales here. It's not urgent in the sense that we have to put in place the processes, the education, the precautions in place over the next few months. But we have, I believe, and our future lawyers won't thank us if we don't do this. We have a few years, basically, to prepare for this change. I think it's entirely within our contemplation. By the time 2030 comes, for example, the AI systems for everyday law will be able to, in a very reliable way, help people understand their entitlements, help them understand options open to them, and you'll be able to communicate with them as fluently and as easily as we do with human beings. That's not many years ahead. And so to put it another way, I think what we're going to see in the short term is automation. That what people are mainly using AI for in law is actually not game-changing. It's just allowing them to do the things they've always done more efficiently. It's about efficiency and productivity, and that's why there's quite a lot of excitement amongst law firms. They say, oh, here's a way that we can take some time or cost out of what we do. It's perhaps a way to be more profitable or more competitive, and I understand that. But that isn't in doing anything other than applying AI to the existing ways we work. In the longer term, AI will be characterized by what I call innovation, doing things that we couldn't previously do. And for me, the biggest breakthrough in AI, and it doesn't just apply in law, it applies in health and elsewhere, is not that AI will be useful for professionals, but actually AI will empower organizations and individuals to undertake a lot of legal work, to undertake a lot of self-diagnosis and self-treatment planning, to undertake a lot of self-education and so forth for themselves. This is the massive empowering effect of AI. It will be like every person having the best expert in the world at their fingertips. And that's a remarkable prospect. And I say this again, in no sense do I feel this is science fictional. The trajectory is very clear. And of course it seems unusual because we've never faced anything like this before. But we've never actually faced anything like the advances we're currently seeing. So let me take you on a bit of time travel to try and explain how we got to where we are. The field of AI, in one sense, was invented by science fiction writers. There was much science fiction writing in the 19th century. Frankenstein's a very good example, which in many ways foreshadowed what we're now seeing, or I hope we're not seeing, in AI. But AI became non-fiction, I believe, in 1950 in an article written by Alan Turing called Computing Machinery and Intelligence, which essentially was in Mind, a philosophy journal. And he, for the first time, systematically explored the idea of computers having, in some sense, intelligence. And then in 1956, there was a gathering in Dartmouth in the United States where a number of leading and very eminent scientists got together to contemplate this idea of AI. The term artificial intelligence was invented by the man in the top left, John McCarthy, who invented the term where he was making a bid for some finance. He was trying to get some financial support for this workshop, and he invented the term artificial intelligence. Around that time, and they were both at the Dartmouth event, was the first AI system called the Logic Theorist. And this was the first time that anyone had moved from the idea of computers being used for number crunching, for mathematics, for logic chopping, for code breaking, to the idea that these systems could actually be used for what they call symbolic processing, problem solving. And Herb Simon, just to give you an idea of the weight of the person, won a Nobel Prize in economics. These were serious individuals doing fascinating work. The first international symposium on AI was in late 1958. And this is interesting for us because this was the first time anyone seriously expressed the idea of AI in law. There's a French gentleman called Dr. Lucien Mel. And a couple of years later, at a big conference in California, a chap called Reed Lawler put a lot of flesh in the bones and gave a more articulate version of what AI might mean for lawyers. that, as you see before you, was the front page of my undergraduate dissertation, which I wrote from 81 to 82. That's how I first became involved with AI as an undergraduate law student in Glasgow University in Scotland. And that was the quotation that set my mind on fire. Now, after this period in the 60s, there's all sorts of research done in AI, a couple of interesting breakthroughs in AI, but from the point of view of AI and law, two seminal articles in the 70s, one by two chaps, Buchanan and Hedrick in Stanford Law Review, some speculation about artificial intelligence and legal reasoning. And then in 1977, another remarkable piece, this time by Thor McCarthy, who had developed, I think we can probably say the first, at least prototype AI system for lawyers, which I think was 1973. This paper in Harvard Law Review was 1977. But these were the seminal research papers of the time, and actually reading them today, they are remarkably prescient. Now, I came into it in the 80s, and that was my doctorate, but I came in when we were developing what we called first generation, or I call them first generation AI systems in law. Of course, at the time, we didn't think they were first generation, we just thought that was AI. But what I want to say to you today is we can think in terms of two generations of AI systems in law. And the first ones were called rule-based expert systems. And I mentioned that I developed a fully operational one, or co-developed it. This was it. And I also want you to know that in the late 80s, we regarded this as cool. We thought that was a good design, and now it's just faintly embarrassing. The system advised on the law of limitation, or one aspect of it, that basically advised people, or it was designed for lawyers, very specialist area of law, and the expertise came from the chairman of the law school in Oxford University, who'd written a book on this piece of legislation, the Latent Damage Act 1986, and all the case law. And essentially what we did, and this is what you did in the 80s when you were developing AI systems, you developed a huge decision tree, a huge flow chart. And our system had over 2 million paths through it. And it was hard to believe, but 2 million paths that we handcrafted. And we showed for the first time you could take a complex area of statute law and of case law and essentially reduce it to code. This was before the World Wide Web was invented. And so it was in the days where floppy disks genuinely were floppy. We had to distribute the system in 5¼ floppy disks. And the system itself, Philip Capper, who was my collaborator, says to this day, the system was better than him. So this was over 35 years ago. We developed an AI system in law that exceeded, albeit in a very narrow area of law, but exceeded the performance of any human being. But there were three things we didn't anticipate. One was the coming of the World Wide Web. The second was what we call brute force computing. And the third was machine learning. The web was an amazing breakthrough for all of us who were working on AI. And it's hard to imagine. In the 80s, I sat with my personal computer and I was on my own. I wasn't connected to anything or anyone. You're a little isolated island, disconnected. And then suddenly, and I just want you to empty your minds of what you know today, but from suddenly just having essentially a typewriter, this thing that produced some text, this idea that you were connected to millions of people around the world, that you could access information that they made available, that you could make information available, was unbelievable. And almost all of us working in AI gave up on AI for a while because we'd found a more practical, a more pragmatic, in some ways a more commercial way of making legal content, legal guidance, legal documents available online. Not nearly as advanced or sophisticated as the legal problem solver we developed, but pretty amazing. But then in 1997, we heard news that the world chess champion, Garry Kasparov, had been beaten by a computer system called Deep Blue, developed by IBM. And in the 80s, we thought that would never be possible, because in the 80s, when we thought of these big decision trees, we didn't have the computing power to explore many moves ahead. But what we'd underestimated was the exponential increase in processing power. And by the time Kasparov was beaten by Deep Blue, this was a system that could explore more than 330 million possible moves in 1 second. A good chess player can juggle about 110 moves in his or her head at one moment in time. So Kasparov, in a sense, wasn't beaten by a machine that mimicked him. It was beaten by brute force computing lots of data and clever software. But it gave us a sense that something quite interesting was happening. The processing power was increasing at a remarkable rate, that our development of the algorithms, the software was becoming more sophisticated, but also that we were developing the techniques for capturing and storing and manipulating huge amounts of data. And this opened the door to a move away from systems that were programmed, where we explicitly represented the law within these systems, to a new category of systems that in some sense learn. Now, how did they do this? Well, it turns out that if you gather together large enough quantities of data, then our systems are superb at, for example, identifying patterns or regularities or trends within the data, but they can do two further things. And this takes us to the heart of what we call the second generation of AI systems in law. We call them machine learning systems, and there are two kinds. There are predictive systems that make predictions, and there are generative systems that can generate. Now, if you're an AI person, you'll say they're both predictive, and you'll be right, but just think in terms of what they do. They're predictive and generative. Looking at predictive first, my favorite example is Lex Machina, developed by Stanford University, bought more recently by LexisNexis. Many things said of it, but the most interesting is that it can predict the outcome of patent disputes in the United States more accurately than any patent lawyer. But it knows nothing about patent law. It doesn't search across the full text of patent judgments. What it has instead is about 200,000 record of past patent cases, who the judge was, which law firms were involved, which lawyers were involved, the name of the parties, the nature of the claim, the size of the claim. It turns out if you have enough objective data about past cases, then you can make more accurate predictions in some occasions about the outcome of court decisions than using the legal method. Now, many lawyers say this is disgraceful, it shouldn't be allowed, it's dangerous, knows nothing about the law. But I go back to the question every client asks. Every client asks when there's a dispute coming over his or her horizon. The question they ask is, what's our chances of winning or losing? Let's go back to the hole in the wall and the power drill. The answer that the client wants, the hole in the wall there, is a probability. But we think they're asking for a power drill. We think they're asking for lawyers and legal method. Do you remember Abraham Maslow, the organizational psychologist, once said, if you're a hammer, everything looks like a nail. Well, I think if you're a lawyer, everything seems to look like a legal problem. And so when the client says to you, what's our chance of winning? We as lawyers, I'm a lawyer myself, we think that's an invitation to invoke the legal method. But here's the key point. If we can develop systems that can answer clients' questions more accurately, more cheaply, more conveniently than lawyers using the legal method, the market will show no loyalty to our traditional ways of working. And I saw people agreeing when I said that this was dangerous about Lex Machina. The market will show no loyalty to our traditional ways of working if alternatives are responsibly and demonstrably superior. And it's not just in law I say this, in my work across the professions. It's true in the way we practice medicine too. It's true the way we undertake audit. It's true in the way tax advisors work. For all professions, we have a way today of solving particular categories of problems. But if these increasingly intelligent, or rather capable machines can outperform us, can deliver what the market wants, or can make it more affordable for people who have no access, we have to take this seriously. And it's not just in predicting the outcome of disputes. It's, for example, document review and litigation. Huge piles of documents. These systems can predict effectively, after some training, which documents experts would identify as the most relevant for a case. In a big due diligence exercise in corporate law, they can do the same. They can also predict deal outcomes. And in the future, and this is for people in businesses, the holy grail, these systems, just as when we test for blood, and blood can show early markers of disease process, we will develop AI systems that can search across the data of organizations and find early markers of legal risk. And that will help put what I call the fence at the top of the cliff rather than the ambulance at the bottom. As lawyers, we're working generally at the bottom of the cliff. We don't have the methods, the systems, the processes, the technologies to put that fence at the top of the cliff until now. So that's predictive AI. Let's think now instead about generative AI. And generative AI is a very different kind of beast. These are systems that can generate text, that can generate music, that can generate videos, animations, and crucially, they can actually write code themselves. A very respectable level of computer programming is now being demonstrated by these systems. And the story, this particular story, I'll say in a second, a new chapter in the story of AI, began with the launch of ChatGPT. And suddenly we saw a system that could summarize documents, draft documents, compare documents, visualize documents, that could help people organize evidence, create timelines, could help actually generate legal arguments, could help conduct research, could answer legal questions. Now, I accept fully that these systems make mistakes today. People love talking about the hallucinations. But please don't suffer from what I call technological myopia. Technological myopia is evaluating the future potential of a technology in terms of today's limitations. The investment that's going into these systems, both the finest minds and huge amounts of capital to overcome the current problems. These problems of today will be overcome, in my view, within 5 years, that all of this will be done not just competently, but actually to a very high quality. So what do I think of all of this? Well, for me, it's the most remarkable development I've seen in 40 years of AI. It wasn't expected by most computer scientists, who said for many years yet, AI would only be able to operate in very narrow areas. That was simply wrong and misleading and will, in retrospect, I think, prove to be one of the damaging mispredictions amongst human experts, because it delayed for many years the precautions we need to put in place to contain and control some of these technologies. We were assured that high-performance, general-purpose AI was many years away, and it wasn't. The chat is really good. The way the system can mimic your interaction with another human being. I find myself saying please and thank you to the system. Ridiculous. I find myself wanting to apologize for the system for asking it the same question again and again in a slightly different way. It's very hard, I think, if you use these systems, not to feel you're in some sense interacting with something that's more than just a bunch of ones and zeros and a lump of hardware. But then here's my big point, really. Generative AI is a new chapter in the story of AI. It's not the first chapter. AI wasn't born, as many people think, in late 2022. I've said to you, it was born in 1950. And it's assuredly not the final chapter. In fact, it's an early chapter. I believe we're still at the foothills. And I think regulators and legislators who are fixating on generative AI, and lawyers too, when they're thinking of their future, who are thinking only of generative AI, are missing the bigger picture. The bigger picture is increasingly capable systems. Generative AI is one of the enabling technologies. Our systems are doing more and more at an accelerating rate. So generative AI is, I think, above all significant because it gives you a sign of things to come. A little story. I write for the Times in London. And they asked me in early March 23, would I write an article on the impact of AI on law? So I went to ChatGPT and said, could you write 1,800 words for the Times about the impact of AI in law in the style and based on the work of the British author Richard Susskin? Out comes this 800 words. Not nearly as good as me, of course. But actually, I then went to GPT-4, and it was a lot better. And so here's my point to you, that hand on heart, I don't think by the time we get to GPT-7, I'll be writing articles for the Times anymore. They won't be needing me. They won't be asking me. And that's the strategic question for all of us. What does GPT-7 as a concept mean for us? If you look at the idea of one individual expert writing a column, it's a slightly strange thing. Why didn't I say, based on the work of Richard Susskin and the other leading experts of the world, why only me? And why did I get it to write in my style when I could have asked it to write in the style of Ernest Hemingway or someone better? And you begin to see that insofar as newspapers contain insight, I think we'll look back and smile and think it's unbelievable we thought the insight of one individual was worth looking at, because we will be able to synthesize the content of many. I think, for a different reason, which we can go on about in a conversation afterwards, the same does not apply to the writing of a book. But nonetheless, the same does apply to a lot of legal business. You might say, well, hang on, I'm a lawyer, I think, I reason, I'm creative. A machine can never be creative. It can never reason like I can as a human being. But that's committing what we call the AI fallacy. And the fallacy that my son and co-author Daniel Susskin and I talk about is the mistake to think that the only way you develop systems that perform at a high level is somehow to replicate the way we work. So this is what a lawyer is saying. A lawyer is saying, here's how I solve problems. I can't see a machine can ever solve a problem the way I can, and therefore I'm safe. Aristotle will have told us there's a grave logic problem there. But that's like basically saying there's only one way to make a hole in the wall, and that's the power drill. And of course, there are many ways, and there will evolve better ways. No one thinks this is a good idea. No one thinks the idea of how you get a self-driving car, an autonomous vehicle, is by putting a robot in the driving seat of a normal car. Of course not. These systems aren't driven by robots or humanoids. They're driven by data. Entirely different conceptual design. But lawyers who say a machine can't work like I can are saying that the only way of getting a self-driving car, or the equivalent, is essentially by putting a robot in a car. Is that not a bizarre way to think? I find it very troubling that this is how we reason and ponder our future. Can machines think? Well, excuse me a second. Can machines think? Does anyone ever hear? Actually, sorry, I wanted to go back because it was in my mind there. If you saw me straying, has anyone ever been in a self-driving car? So, a couple of people. So I was in San Francisco recently, and I went in a Waymo car. Waymo was a company that grew out of Google. And I thought before I went, it's funny because I write about these things, I thought a self-driving car might have a human being in there to grab the wheel, or I thought it would only work in a car park. And I go to San Francisco, and we dial up for this thing to come, and an empty car comes up the road. And you go in there, and it starts moving along, and the wheel's moving. It's like being driven by the invisible man. It's quite unbelievable. And at one stage, we're going around a big curve, and then down there is about 300 and 400 feet sheer drop. And I'm with my wife and my daughter and her boyfriend. I'm thinking, what am I doing? It was completely unbelievable. We can talk later, for those of you who've used it. It's remarkable. But it did make me think, goodness me, if we can actually get these self-driving cars operational, so much of what we do surely in the professions can be undertaken by technology. So back to this story. This is answering the question, and let me repeat the question, can machines think? In 2011, again IBM, interestingly, developed a system called Watson that appeared in a TV quiz show in the United States called Jeopardy. And Watson beat the two best ever human Jeopardy champions. Next day, in the Wall Street Journal, a man called John Searle, a well-known philosopher who's commented on AI, wrote this. He said, Watson doesn't know that it won in Jeopardy. Isn't that perfect? Watson didn't want to go down to the pub to celebrate. It didn't want to phone up his mum to say it won. Watson is an incredibly high-performing but non-thinking machine. Let's be clear in that. Everyone's saying just now, in the media and in conferences and blogs, what does this mean for lawyers? What's the future of law firms? What's the impact on judges? When there's a medical breakthrough, people don't ask the question, what does this mean for doctors? We think, what does it mean for patients? But I'm afraid, and I say this again as a lawyer, we are unforgivably self-oriented. We think when we're discussing about AI, it's all about us. It's almost nothing about us, in fact, in the long run. And this is what we need to think about. So what jobs are we going to be doing? Who are these people? Legal design thinkers, legal knowledge engineers, legal data scientists, legal risk managers. Who are these people? These are the people who will be designing the systems that will replace our current ways of working. These are the people who will be designing the systems that'll be solving the problems of tomorrow's clients. And that's why, controversially, in my book, I say they're tomorrow's lawyers. And this, of course, is a huge challenge to law school because we're not producing these people. We're producing people to work in the 1980s. I don't mean this law school, I mean every law school. We're producing lawyers to solve legal problems in the traditional way. We're generating more power drills. But in the future, someone's going to, and looking very long term, I accept machines themselves might be developing these systems. But for the foreseeable future, for me, the great excitement is being involved in building the systems that replace our old ways of working. And that is what I think our law schools need to prepare the next generation for, as well as conventional understanding of the law and legal concepts. So that means as law students, as lawyers, you have a basic choice for your future. Do you compete with these emerging systems or do you build with them? By competing with them, and many law professors say this to me, they say something like this. They say, I understand what you say, but you're probably overstating it. You don't really know what goes on in our jurisdictions. There's so much that we do as lawyers that machines will never do. There is nothing, for example, in the literature of labor economists just now who are looking at the future balance between human and machine labor, which is suggesting there's more work going to human beings and less to machines, quite the reverse. So to compete with these machines is swimming against the tide. But in the alternative, you could be involved, I say, in building the systems that replace our old ways of working. So in terms of strategy, very briefly, for law firms, there's three things they can do. They can listen to what I've got to say and say, we've got to optimize. We use AI to optimize. Carry on what we're doing, but we need to optimize. I say that's not enough. They might say we can use it to transform, and I think that's more like it. If you look at my book, Online Courts and the Future of Justice, the future of dispute resolution is not an automated version of what we have today. It's something that's transformed. It's something very different indeed, and we need to prepare young lawyers for that. And I also think we should diversify. When I speak to in-house lawyers, I hear they're being asked to take responsibility, for example, for AI ethics. They're being asked to take responsibility for the management of reputation within an organization. They're being asked to look after cybersecurity. So I think we as a profession actually might widen our ambit. But let me finish, because I'm conscious of time, of neurosurgery. I was invited in 2017 to give a talk to 2,000 neurosurgeons in Boston. This was about the book, The Future of the Professions. Scary audience. They asked me to be controversial. My opening line, I said, patients don't want neurosurgeons. Gasping audience. I said patients want health. I said, for a certain type of health problem, you're the best answer we've got today, and thank goodness for you. But I said, don't you think in, say, 20 years' time or 40, I don't know, but sometime in the future, people will look back and say, it's unbelievable how often we used to cut human bodies open. Because I said that day, and they agreed, the future of healthcare was not as what they thought I was going to talk about, robotic surgery. It's non-invasive therapy and preventative medicine. And we have to get into this way of thinking in law. It's not about robotic lawyers. It's not about automating what we already do. It's about transforming what we do. It's about meeting the communities and business needs, the equivalent of non-invasive therapy, more quickly, more cheaply, more conveniently, but fundamentally differently, and using technology. And it's also surely about preventative services as well. We've got to borrow from preventative medicine and have preventative lawyering, because that's what clients want. They want to be kept out of trouble. They want that fence at the top of the cliff rather than the ambulance at the bottom. But I also realized, and in conclusion, in asking me the question, what's the future of neurosurgeons, they were actually asking me the wrong question. The question they should have been asking me is, how in the future will we solve the problems to which neurosurgeons are our current best answer? And likewise, when people say to me, what's the future of lawyers? I say that's the wrong question. The question we should ask is, how in the future will citizens and organizations solve the problems to which lawyers are their best answer? And my best answer to that, at least in part, is artificial intelligence. Thank you very much.
Dear Richard, thank you very much for this excellent presentation. We have to think a lot about what we do and what we've been doing here in this law school, and we will do that, of course. We have a couple of questions here, and I would like to invite everybody around. If you have questions, please step in and we can have a nice conversation. My first question would be, I know you have kids, right? Would you recommend them to study law today?
Well,
yeah, please.
I have 3 children, actually, 3 grandchildren as well. So my second son is a barrister, but he's also an author, and he writes on the politics and the regulation of AI. My first son's an economist who also writes about AI. And my daughter is currently working in Silicon Valley, and she works in startups, largely in AI as well. In one way or another, it seems to me if you're not working in AI, you're going to be struggling because it's going to be so pervasive. I think the question, what work will our children do, is one of the great unanswered questions of our time. Daniel, my economist son, has written a book called A World Without Work, where he analyzes that at great depth, and I think it's a great book. I would say that, but I think it is a great book. But he looks at the economics of this because we can clearly envisage a world where much white-collar work is no longer done by human beings. So we have a couple of very big questions that arise. One relates to the concentration of capital and power in the very small number of organizations that actually own and control these systems. Because although we can envisage a future where economic productivity in ways he shows will increase, the way in which that pie is divided is a different question altogether. And we do run the risk of greatly accentuating the rift between the rich and poor, the rich being those who basically run and control the systems, and the poor being the rest of us. So we have huge political and in turn legal decisions to make about that. And the second question is, to what extent will there be anything left for human beings to do? What is it that we think that will distinguish us? And if we haven't got work to do, can we have a meaningful life? So all of these questions are up for discussion, and he has a go at least laying them out. I no longer, when people ask me to give talks on 2050, for example, I now say no. Now, I wouldn't have dreamt of saying that. I've written a number of books, and my first set of predictions was in 1996, and I was quite happy to make a 20-year prediction then. And I think my nervousness is an indication of how much I think the technology is going to change, and new technologies of which we're unaware. And incidentally, this is nothing in any sense to take away from the importance of the debate over climate change, but when people talk about climate in 2050, they're talking about human beings from 2024. Whereas by 2050, human beings will be, or at least some, will be very largely digitally enhanced. We'll be sharing the planet with systems that are wildly, unfathomably more capable than us. I'm not saying that means the climate change problem goes away, but I think it is slightly naive to think that just simply to project to a world where humanity will be as much as it is. My own view is humanity over this 25-year period will see greater change than it's seen in the past 300,000 years, the history of Homo sapiens.
Who would you recommend today to study law? I mean, in the old days when I was young, right, you were studying law because you wanted to have a prestigious job, you wanted to have a great salary, you wanted to do an interesting work, you maybe wanted to have a nice assistant, whatever, you know, those attributes you thought are combined with lawyers and legal work out there. What do law students today face in their professional field? Why should they do this?
It's interesting you say that. When I started in the law in the late 70s, early 80s, and while it was a good income there, it wasn't as it now is, for example, amongst leading law firms, which is a superb income. And many people went into law because they were genuinely interested in questions of justice, they were interested in human rights, they were interested in perhaps being court lawyers. But I often say to people, the future is not Rumpole of the Bailey, it's not John Grisham. We're entering a very different era. So one should be attracted to the law, I think, not because of how lawyers currently work, and this reflects my final bit of my talk. You should be attracted by the idea of being involved in developing the systems that solve some fundamental problems. So if you care about justice, if you care about rights, if you care maybe in a business context about trying to make the most of law and regulation to improve business performance, then study law. But don't study law because you want to practice in the way law is practiced today, because by the time you get there, that will be historical. And I really think it is going to move very quickly. But I've said to you, not 2 or 3 years, but if you contemplate studying law, if you're at school just now, and you look, say, 10 years ahead, within 10 years, I think we will have seen remarkable change.
You also said that lawyers in the future need to know much more technology than they know now. Regarding me, I can see that clearly, right? My limitations are huge. Where should those future lawyers learn that skills? Is this something law schools should in a way teach, or should there be some kind of professional practice school, or do they learn that on the job?
So I'm not saying that lawyers should become programmers. I also think that, as I've said to you, I think we'll have systems that will design better programs. There is now a discipline called no-coding, where people who can just think in a structured, logical way can actually develop very advanced systems. But let me give you, my answer to your question has changed over time. So my book, Tomorrow's Lawyers, is now in its 3rd edition. In the 1st edition, when speaking explicitly about law schools, I said, it's a very busy curriculum. I understand that most law deans won't want to give space amongst compulsory subjects for all of this stuff. So I said, I think there's 2 sets of options that should be offered at law school. The first is to be able to study legal futures. It's not just me who's written books. There's a whole literature in this. There must be 30 pretty good books and hundreds of articles on the future of legal service. Because when I give lectures to undergraduates, the look in their face is, frankly, why has no one told about this before? And in the United States, I get particularly quite angry response. People say, we've borrowed hundreds of thousands of dollars and no one told us that legal practice is not going to be like my next door neighbors or my fathers or my uncles. And I think we owe it to our students, and I said in the first instance, as an option for them to be immersed in the literature. The second thing I said is, and I had a smaller list then, it was about 10, I said there's new skills. And I think we should again offer that as an option. You should have the option to be able to learn about legal process analysis or legal project management or legal risk management. And I said it would be great to get practitioners in from law firms who are doing this to actually and work more closely with the profession. But I've changed my mind on this because I don't think these should be optional anymore. And I actually think they should be compulsory. I think it's absurd that a law student is not exposed to this kind of thinking. It's not because I wrote the book, but I find it unbelievable when I meet a law student and they've not heard of the kind of work I'm doing and other people are doing. How on earth can you go through 3 years of legal studies in an internet and AI society and not have been at one time exposed to this thinking? It almost beggars
belief. One law school does this nowadays already?
I'm a law school professor myself, so I do know. And at Strathclyde University, which is my oldest affiliation, we were running a joint computer science and law degree in the 80s, and we still think this is important. Second point is more skills training, and maybe that I can argue that's not an option for universities, and maybe that should be done in professional exams, or maybe it should be done as ongoing legal education. But I stress again, and I'm stressing it strongly because I feel strongly, I think we are ill-equipping and letting our students down without them hearing this kind of thing, without them being exposed to the growing expertise in this area. And putting another hat on, I advise many of the world's leading law firms. I advise their managing partners, the people who run this is all they're talking about just now. This is top of their agenda, this future. And they say to me there's a disconnect between what's going on here and what's going on in the academy. So it's a big challenge to you. I'm not going to sweeten the pill. Sorry if it's too challenging, but that's what I'm here to do.
That's why you're here. That's fine. Thank you very much. I was a bit relieved to learn that there are limits for artificial intelligence, right? Also in the area of law. You said artificial intelligence is not going to write books, right? So where are limits? Where are safe haven for us?
No, that's not what I was saying. I was saying, because I actually think AI can write books, and I think, but I was actually saying, I didn't develop it, I just said I think as an author I was safe. So here's my thesis on this, but let's think about sport. We can design robots today that can run faster than Usain Bolt. I wouldn't want to go to a stadium to watch robots racing. We can, I think we'll be able to design systems that will be able to perform musical theater. I'm not interested in that either. I think as human beings, when we move away from when we move into the arts, when we move into music, when we move into creation, it's not just the content that we enjoy. It's actually the fact it's been written by another human being. I think we value that. And I think we get great pleasure from seeing great human beings in action. We call it vicarious pleasure. And so I think the reason people might, I hope, want to read my book is precisely because it was written by a human being and enjoy the idea that this was a fellow human being writing it rather than a machine. I'm not saying people won't want to read long machine-generated text, but as I say, it's not just about the content when you come to the world of creativity. Now, that's very different from things like healthcare or tax accounting, where actually you're simply wanting an outcome. I think in the professions we're too preoccupied with how we do things rather than the outcome, whereas the patients and clients, they're interested in the outcome. I think in the arts, we're actually quite interested in the process as well. I want to know how a great author writes his or her books. I want to know about the creative process. How did you do that? That matters. So that's why I said, it's not that I don't think a machine could generate, and I think they will generate books that will be, in some sense, way better than anything I could ever write, but I still hope people will be quite interested in reading good stuff from good human beings. But it's not, when it comes to the arts, it's not just about the outcome. Now, the complication there, of course, is when you listen to a piece of music or you look at a piece of art or you read a book, you might not know if it's been generated by an AI. So it's not simple or straightforward.
You mentioned Uber law, for example, or Amazon law, or Mac law, or whatever can be around there. So that a lot of work that so far has been done by lawyers will sooner or later be overtaken by some kind of artificial intelligence programs. What is then left actually for lawyers? Where are human being lawyers asked to step in? What is the difference between artificial intelligence and the human being, the lawyer in the office or whatever?
I mean, in generic terms, in the long run, if it's only about outcomes, I don't think I genuinely not sure there's much left for human beings. And I think this right across white-collar work. I have a different conception of work from most people. It gives my life meaning, it gives life much of my meaning, but I can imagine a world without work, I really can, and that's my son Daniel's thesis is about. This is why I'm saying, I'm not here to talk about the automatic generation of contracts. I'm here to say to you that humanity is at an inflection point. Over the next 10, 15, 20 years, we're going to see unbelievable changes where some people who are way more scientific and eloquent than me, an expert than me in the world of AI, will say we're coming to the end of the human period, and our main contribution will be to create these far greater intelligences. So I'm being pretty low key today. I'm trying to keep it local. But I know you want to be able to say to me, oh, here's the 4 things that lawyers will be able to do in 2045.
Checklist,
it's going to be really important. And and someone in the audience is going to say to me what my clients really want is a trusted advisor. And I'm going to say, actually, that's not what we want. That's probably what you are. But that's not what the client wants. The client wants an outcome. It's a bit like if we happen to find and I wish we would, a universal cure for cancer, we would not be saying, no, what people really need is a trustworthy oncologist. We just wouldn't be saying that. We'd be saying this is phenomenal and it's a shame for oncologists. But we wouldn't be, and we shouldn't be hanging on to our old ways of working.
we're right back at the days of, it's like hanging on, what are blacksmiths going to do? Because cars don't need horseshoes, and we should keep horses because cars don't need horseshoes. We have to realize we're at that kind of inflection point. It's like the printing press. It's of that magnitude. And so what I've done in one of my pieces of work, in my book, The Future of Law, in '96, I've said humanity has evolved through now, we're in our fourth phase. The first phase was the era of orality, where our only ways of communicating as human beings in primitive societies was orally. These societies, legal anthropologists will tell us, they weren't free of norms or rules, but they had senior elders who often essentially generated the rules and settled disputes. But when script emerged, we had an opportunity to be able to record more law with different ways of transmitting and recording it, and the legal structure changed. The same with print. And what I suggest to you is when the main way in which the law or rules or norms can be stored and captured and reproduced and applied, when the main way of storing information in society changes, then the law will change. And it's changed from primitive society to script-based society, it's changed into print-based society, and it will change again into a fully based AI, internet-based society. So it's perhaps our way of looking at it in terms of major epochs. And if you look in contract, for example, where we move from status to contract, where we move from societies in which agreements were based mainly on trust and status and relationships between human beings to something more formal in the shape of a contract, that's very much the product of a print and a script-based society. And I could imagine we might have entirely different ways of contracting in the future. Contracting is the wrong word, of coming to agreements. I think we're coming to the end of the standard period of contract. So if this affects substantive law as well, and scholars should be looking at this, but you only need to sign a Microsoft or an Apple software agreement online to see how daft it's become. We all just press agree. And what are we agreeing to? No one knows, no one understands it. When lawyers look at it themselves, they don't really understand it, and they're amazed that and so it's not just what will lawyers do, it will actually be, what will the substantive law be? What kind of rules will be in place in an AI-based society? Another example of that is embedded rules, so that, you know when you play the game in your iPhone, you play the card game, which it's called Solitaire. When I was young, we played it with playing cards, physical playing cards, and we called it Patience. Now, what would happen when you played that game when you tried to put a red 4 under a red 5? It's called cheating, but what would happen? You could do it. You could place a red 4 under a red 5. What happens when you play the game on your iPhone and you try to put a red 4 under a red 5? The system rejects the move because the rules are embedded in the system. And that we will see right across our institutions. As more and more of our organizations are based in technology, the rules will actually be embedded in the system. And this has profound implications for freedom of thought, actually, but also, to some extent, freedom of conscience. That we will actually, the whole idea, for example, in big financial institutions, you have in the university today the president of one of your major banks speaking, and they will...
The only major bank, I have to say.
Well, they will spend billions on compliance, and that's human compliance. We won't have humans in the loop, because that same bank is developing massive electronic workflows for all aspects of its work. The way to ensure compliance is to build compliance in the system. So let's go a step back. And I'm just throwing out ideas because there's so much here. I wrote an article for the Times recently on this. I've been experimenting on using just ChatGPT to draft legislation, to draft regulations, and it does so at a very high level. But I then asked it, after drafting regulations, I said, could you produce me a flowchart of that regulation? Funnily enough, 3.5 is better than 4 in that, but it immediately produced a flowchart. I then said, could you translate that regulation into the computer programming language Prolog, which is the language I used in the past? Did it instantaneously. we're going to be moving towards a world where we can legislate, not just in words, but we can actually generate executable code that can be then directly put into our organizations. This is just where it's all going to happen so quickly, and we're so ill prepared. And you're asking, and so when people say to me, what is it that humans can do that machines won't be able to do, I go back again to say I'd love human beings to be involved in the designing of these systems, because that's where the action is just now. We run the risk of being left behind.
But who is going to make the rules in the future, right? Who is involved in the legislative process? Will people accept decisions by an artificial judge, by a machine, that is producing a decision of a court? Would that be acceptable among people?
Well, you're asking two different questions there. I think one, how will it affect our legislative processes? I can't speak for Switzerland, but our legislative processes are beyond a joke. I don't know if any of you have watched our House of Commons, the bickering, the arguing. When you speak to people who are not lawyers or legislators, is this really how we're generating content or generating rules? And are these people really representing our interests? Through AI, we will have far better ways. There's already what's known as sentiment analysis of assessing and determining what it is that most people want and feel. But we can do that in real time. And if the rules are embedded in executable form, you will be able to change the rules in real time as well, according to different changes in public opinion. Again, I'm just throwing out thoughts. You've got to think completely differently. The question, can computers replace judges? I mean, it takes me right back to my own doctorate. If you don't mind me saying so, I think that's the wrong question. I mean, you can ask that question, but if you want human judgment, you have to go to a human lawyer. This is why when people say machines can't be creative, I think, well, that's probably right, because creativity is a human characteristic. Similarly, if you want human judgment's a human characteristic. So the bigger question is, do we want human judgment, or do we think there might be other ways of a state providing dispute resolution mechanisms that are backed by its coercive power? And my aim in all of this is not to say let's get rid of judges, but it's to ask, certainly in jurisdictions where if you take, for example, Brazil, where there's a backlog of 80 million cases, or you look at India, where there's a backlog of 40 million cases, my question isn't how can we improve the work that these judges do, it's can we find entirely different mechanisms for resolving disputes that precisely don't involve human judgment. Do you know what we've got no shortage of, and that's human judgment. We've got quite a lot of human judgment, but might we begin to have confidence in systems that work in entirely different ways? Now, one way these systems can work actually is saying, so you could have two people in dispute, you and I might be in dispute, and the court will say, your case will not be heard for 300 or 400 years because of the backlog, but we have an alternative here. We have a system that can predict what the likely outcome of this case would be. And so you run the system, and it says, in your case, there's a 95% chance that the judges would decide in one way. And then you and I would have to say, would we, probably as a matter of contract, agree to accept that output as binding? So that's how you'd use predictive AI. You'd use generative AI because it's getting better and better. And I do think we'll be able to essentially feed in the facts of the case, and it will come out with a conclusion. Now, many people say what it can't offer is a reasoned judgment. And that takes you into very interesting jurisprudential territory, because it's not clear, and there's a lot of legal philosophy on this, it's not clear that the reasons judges give for decisions are the actual reasons. I'll tell you what judges give as their reasons is certainly not their neurophysiology or what's going on. It's not the description of their brain states. So somehow I think people want more of the machines than we get from human beings. I think human beings provide a kind of rough and ready rationalization in a structured syllogistic form. A machine will be able to do that as well. So frankly, all bets are off is my point. And I don't mean it over the next couple of years, but we need to be having debates. We need to have great legal minds. Professors say, hang on a second, Richard, you're wrong on that, or what about this, or how do we put precautions in here? So here's another thought for you. In medicine, we have randomized control trials. You don't just allow a new pharmaceutical or medical advice in the market. In England, a senior judge or a senior politician comes up with an idea for technology, and it's it's introduced. There's no testing. There's no mechanisms. There's no mechanisms. It's unbelievable. We have no mechanisms for testing, for example, AI systems in law. But if I'm right and these systems are going to help people understand their entitlements, who's going to design all the protocols and processes that allow us to give assurance to the community, to society, that these systems are worth relying on? So these are all the things I think about. And so it's not, I just want to discourage the slightly binary thinking that people go in for, say, well, you know, I quite like AI, but there's lots that lawyers can do, and that's what we're going to focus on. I'm so keen that the legal community globally rises to this challenge rather than, and this is a long answer, but in England, we have, in London, we have things called livery companies. And the livery companies have grown out from ancient guilds, where in the past we had mercers. And mercers were people who worked in silk and sold silk and imported and sold silk. And we had cordwainers. These were the craftspeople who worked in leather goods. And we had tallow chandlers. These were the people who made candles. And we had wheelwrights. These were people who actually handcrafted wheels. None of these people exist anymore. But the market for silk, the market for leather goods, the market for candles, the market for wheels is unfathomably larger than it was when we had these trades, because we found fundamentally different ways of satisfying the market need. And in my book, The End of Lawyers, I start off on chapter 1 asking, I wonder if some time from now, people, the reason I was thinking this was I was having dinner in the Mercer's Hall, this beautiful tall hall. I was thinking, who are Mercers? And I asked the person, the person beside me says, there hasn't been one since 1884. I said, that's strange. They're now charitable. And then I started thinking, but there's still silk. And I wondered, might it be the case in 150 years' time? People look back, who are lawyers? What did they do?
Frightening,
So
right?
could law and the professions fade as ancient crafts have faded?
Interesting thoughts.
Sorry for ruining your dinner, everyone.
I would like to open the floor and to see whether there are questions from you and comments or whatever you might have to add to Richard.
Thank you, Professor. I'm your friend from Ukraine. And 5 years ago, I remember that people were surprised that LLM in engineering conversation meant large language models. Now you see it's LL.M, means legal LM, but now we have LLM as a part of AI neural system. That's why my question is, what lawyers should know to keep up with LLM without dot, and maybe what we shouldn't study, what we shouldn't do to be in this era inside of progress, not outside. Yeah. Thank you.
The question is about what we should know and not know. I'm not perhaps mainstreaming this. A lot of lawyers, I find, are, in my view, spending too much time in the technicalities. So they're really trying to, and I know, I'm half a technologist, so I know a bit about technology, and I hear them talking, and it really is very amateurish, but they're really keen to learn, and they're trying to learn about it. And I think it's mistaken for two reasons. A, they don't have the mathematical or technical background, but B, the technology is moving so quickly that it's not a great use of your time trying to understand the technology. Yeah. There is some systems thinking is a good way of putting it. I think we need to try at a higher level. We need to be able to understand the potential, the limitations, the design of these systems, rather than try to become ourselves specialists in how they work. I go back to my point from Stephen Wolfram. Stephen Wolfram doesn't understand how they work. It's unlikely that a lawyer working his dining room table is going to master this. But what a lawyer can think deeply about is how this technology can be deployed, can try and understand from people who are writing about it, about what its potential limitations are, where its greatest promise lies, what its limitations are, what precautions should be put in place when we should be worried and so forth. And so I think as this relates to my thing about lawyers not becoming programmers. We've not got to get confused there. I know it sounds very trite, but we don't understand, most of us, how our car works and we drive it happily enough. And I think that analogy is pretty sound. When we had the early years of legal information retrieval systems, people, as it happens, that used to be something I was interested in, so I knew how they worked. But people want to know how they work. They actually don't. I'll train you how to use it. You don't know how your word processor works. You don't know how your email systems work. You don't know how the internet works. You don't know how the web works. I don't know why people feel that they need to understand LLMs at that level of detail. They need to be reading about its application, its limitations, its uses. Although there is, all of that said, when we're thinking of people coming through, I do like the idea of jointly qualified people who have technical and legal background. I think there's real potential in that. I think it's, I love the group of young people who are equally fluent in law and technology. It's just very hard to do that as a practicing lawyer.
We have about 5 minutes left, and depending on the length of the questions and the length of the answers, we have 1 or 2 chances for questions. Who would like to ask? Please, here is a hand.
Yes. Hi, Richard. Thank you for this interesting insights. Where do you see the biggest impact in terms of, or concerning access to justice, or better access to justice with this transformation going on with artificial intelligence?
Okay. I believe there's 2 challenges in access to justice. Most judges talk about access to justice as meaning better access to the courts. I look at it far more widely than that. I think we have to think of different ways, as I was hinting, different forms of online dispute resolution of the sort I've written about and others have written about. Might be there's a whole bundle of different forms. So I think what we will in the first instance do is find cheaper, quicker, easier, more convenient ways of resolving disputes. The second aspect of access to justice, though, that even having these services available is an empty offering unless people can understand and enforce understand their entitlements for themselves. And that is going to be the big breakthrough, and that'll happen over the next 5 years, where people actually can understand their legal position, understand the options available to them. The system will help them organize their evidence. It will help them impose order in the chaos of their papers and so forth. So it's not enough, as I think lawyers say, just to make the courts more affordable and accessible. We need to have systems that will help guide people on legal issues. And very often, I think legal issues dissolve rather than need to be resolved. So I think challenge 1, systems to help people understand the law. In parallel, challenge 2, develop different dispute resolution mechanisms, maybe from the private sector as well.
That was good, thank you. Maybe one last question to round up. Please, there is a hand.
Thank you. You described how AI is developing in giant steps and how it is getting more and more complex problems solved. How do we ascertain that the quality of the outcome is what we want? How can we follow still the complexities? If they are so fast and intelligent in this sense, how is quality and the values of the solutions, how is that controlled? How is that assured?
That's a question to which I don't have an answer, but I was hinting at that earlier. We know how to do this in medicine, but we don't have it in law. What I can tell you, though, is I don't think the answer is to look inside the black box. I think the answer is got to be, and we can do this with these systems, is to be able to run hundreds of thousands, even millions of permutations and test their outputs. So it's more of an audit process. There's a lot of work going on, and people call it validation, verification. I prefer to think of it as audit, where we will have techniques and methods for assessing their outputs. It won't be foolproof, but one of the interesting things about that question, not in the way you put it, but a follow-on from that is we have to remember that the human process is quite imperfect as well. And a lot of people, when I talk about these things, say, well, the system can't do A, B, and C, and also actually the human beings can't do that as well. So the best can be the enemy of the good here, as Voltaire said. And I think we need to, so the question for me is, when is good enough? And how can we audit systems to be good enough? And we don't have the answer to that, but this is what I'm saying. I mean, it disturbs me that there's not bodies of legal scholars around the world, and I'm thinking this is what I'm going to dedicate the next 5 years to. Because if out there people are relying on this content, it may be to their great detriment. So what could be more important than be studying and thinking this? It's a different form of legal study, developing the methods and techniques, and quite exciting as well, because we need to borrow from other disciplines that we're not normally used to involving ourselves with.
Thank you so much, Richard, for your great presentation you gave here. A lot of things to think about for us, and how we should, guide and organize ourselves for the future, and also, of course, the legal education we have. We are, of course, going to invest a lot of money to buy all your 9 books you have written so far for our law library, and we are waiting for the 10th book you might be probably writing about and providing those answers you haven't given us today yet. So thank you so much. We have brought for you nothing that is related to law or technology, but it's something otherwise fine. It's a chocolate from Switzerland. Thank you very much for coming.